Mr. Gagnon, do you already have this resolved or you need to?
Yeah.
All right, do you have paperwork?
I do, I can go over briefly though. We already talked about it next time.
Okay. Mr. Heller, are you ready for me to call your case?
Yes.
All right. This is the matter of State of Ohio versus Glenn McCracken, case number B2503085. Mr. McCracken is present in the courtroom with his attorney, Mr. Sam Heller, Ms. Paige Hennigan for the State of Ohio. This matter is on today for a pre-trial conference. Mr. Heller, what I know about this case is the last time you were here in August, you indicated that discovery was received and that the parties were in the process of negotiating a resolution. Where do we stand today?
Your Honor, at this junction, I believe discovery is complete. Obviously, I always have to be corrected if I'm mistaken in that belief by the state. We have submitted a formal plea offer to the state. I think there had been some hope we would be able to move on that today. The state does not have kind of all the pieces in order to do that today. So at this juncture, we are comfortable moving forward as scheduled. We have a fever trial on November 20th.
That's the final pre-trial conference.
Correct.
Yes. All right, and then the jury trial is December 1st. Ms. Hennigan, anything you want to come on record?
Not this time, Your Honor. Well, I guess I will put a little bit on. So we are in receipt of his offer. The offer has been rejected for now. There was a couple more questions that I needed to get in order that I received today from the officer. So I'll take that back and do what I need to do and reach back out to Mr. Miller.
Okay. All right, so I'll just continue this as already scheduled for the final pre-trial conference on November 20th. But should the parties come to a resolution before that date and notify the court, I'm happy to advance the date for resolution. Okay? All right, time wait until the trial?
Yes.
Thank you very much. Mr. Kraken, please keep in contact with your lawyer. Thank you. Have you heard from Ms. Molly? She just texted. Mr. Fox, will your case be going to trial?
we're waiting on an officer to potentially appeal the
Okay,
question.
sure.
If the reduction does not occur, then yes.
Okay, I understand.
First hearing.
It's, Paige Hennigan.
Okay, you don't go
No, Mr. Rubin will be back. Will you call Mr. Rubin and tell him he's identity? Yeah, he's on his way. All right, are we ready, Mr. Diamond?
We want to, sorry.
All right.
Thank you. Where is it?
The prosecutor signed it.
Oh, I'm sorry.
This is a matter of State of Ohio versus Patricia Abrams. Case number B2503234. Ms. Abrams is present in the courtroom with her attorney, Mr. Jeff Diamond, and Ms. Paige Hennigan for the state of Ohio. This matter is on today for a plea for a jury trial.
Correct.
And, but I've been, told that this matter has resolved in a negotiated plea between the parties. And I've been handed plea documents. Counsel, is this how your client wishes to proceed today?
Yes.
Ms. Abrams, is this, you want to resolve your case by way of a plea of guilty today? Yes. All right. Are you the Patricia Abrams named in this indictment? Yes. Ma'am, how old are you? 45. How far did you go in school? Graduated high school. So you're able to read and write the English language well? Yes, ma'am. Are you a U.S. citizen? Yes. Have you ever served in the military? No. Ms. Abrams, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Diamond's signature here, right above. Is this your signature? Yes. Can you see it from there? Yes. Okay. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which is set for today. But when you sign this form, you're indicating to the court, I understand that, but I don't want to have a jury trial. I'm waiving or giving up my right to have a trial. Is that your understanding of what you were doing when you signed this form? Yes, it is. Did you sign this form after you consulted with Mr. Diamond about your constitutional right to have a trial? Yes. Do you have any questions about this form? I do not. Do you have any questions about your constitutional right to have a jury trial? No. I also have in my hand a 3-page document, and it's entitled Entry Withdrawing a Plea of Not Guilty, Entering a Plea of Guilty. On the 3rd page of this document, there are signatures. Ms. Hennigan, is this your signature? It is. All right, thank you. She's the first time she's in my room, so now I recognize your signature. I do recognize the Mr. Diamond's signature, but right above here, ma'am, where it says signature of defendant, is that your signature? Yes, ma'am. All right, thank you very much. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Yes, Your Honor. It's the state's understanding that Ms. Abrams will plead guilty as charged to count 1 of the indictment. In exchange for that, the state will dismiss her plea count 2.
Mr. Diamond, is that your understanding?
It is, Judge.
Ms. Abrams, is that your understanding? Yeah. All right. Ma'am, are you under the influence of any medications, any alcohol or any drugs today? No. Do you now or have you ever had to manage any type of mental health difficulties? No. All right. Are you presently under any type of probation or community control supervision in this state or any other state? No. Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today to count 1? No. Has anyone promised you anything at all other than the dismissal of count 2 if you enter into this plea of guilty today? No. Are you making this plea of your own free will? Yes. Now, the state has indicated that this is a 2-count indictment and that you would be entering into a guilty plea as charged to count 1, which is possession of a fentanyl-related compound, a felony of the 5th degree, and in exchange, the state is going to ask the court to dismiss count 2, which is the illegal use or possession of drug paraphernalia, a misdemeanor of the 4th degree. Is that what you talked with your counsel about before this hearing today? Yes. Did you have an opportunity, ma'am, to review this 3-page plea form with your lawyer before this hearing today? Yes. Do you understand what it says? Yeah. Do you have any questions about it? No. Did Mr. Diamond answer all of your questions about it? Ma'am, do you believe you've had enough time to sufficiently consult with your attorney about your entire case before this hearing today? Yes. And has your lawyer answered all of your questions to your satisfaction? Yes. Have you had an opportunity to either review or discuss the evidence that the state has against you with your lawyer, Mr. Diamond, before today?
And when we first met, we went through it. I'll sit down and try to narrate that.
All right, so
deal, I just didn't want to
Well,
give you that answer.
I need to make sure that you know the evidence is against you before you do this plea. So my question is,
Yes, I do.
have you talked about it with your lawyer?
I understand what you're saying. I'll listen to this, yeah.
Okay, all right. Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge to the defense?
Yes, Your Honor, all discovery has been sent.
All right, thank you. Mr. Diamond, you acknowledge the same?
I do, Your Honor.
Ma'am, Ms. Abrams, are you satisfied with your lawyer, Mr. Diamond?
Yes,
Now, do you understand this charge in count 1 against you, possession of a fentanyl-related compound, a felony of the 5th degree?
yes,
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in count 1 of the indictment?
yes,
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
yes,
Now, count 1 is a felony of the 5th degree. Do you understand that you're facing up to 12 months in prison and up to a maximum fine of $2,500?
yes,
Do you understand that if I sentence you to prison upon your release from prison, you could be on post-release control for up to 2 years?
yes,
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence.
yes.
Are you on post-release control?
No.
Right now?
No.
All right. Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, do you understand that the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater?
Yes.
Do you have any questions so far?
No.
Ma'am, since this is a felony of the 5th degree, community control or probation is a possibility. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison?
Yes.
Do you understand that if you are placed on a community control sentence, you would have to abide by all probationary conditions as established by this court?
Yes.
And if I place you on community control and you violate the conditions of community control, then you're going to be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time up to the 12 months I previously discussed with you. Do you understand?
Yes.
Do you have any questions at this time?
No.
Thank you. I lost my voice screaming at the TV yesterday when the Bengals were playing. So please bear with me. I don't know what's happening, but, all right. Can I tell you a couple of ways that people break, violate the conditions of community control? I'm just gonna tell you that because if I put you on community control, I fully expect that you're gonna be successful. But I just wanna tell you a couple of ways that people are not, okay? So the first way that people are not successful is they break the law. All right, that's pretty obvious. The other is that they just don't comply with all the conditions. So if I put you on community control and there are 5 conditions that you need to comply with to be successful, but you only complete 4, that's a violation. Do you understand that? All right, and then the third one, which is not as obvious to people, but it is a violation. You leave the state without permission of the court or probation. Okay? All right. Any questions so far?
No.
Ma'am, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand? When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand before you make your plea. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf?
Yes.
Do you understand that at trial, it is the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes.
And finally, do you understand that at a trial, you cannot be forced to testify against yourself?
Yes.
Do you understand each of these rights as I explained them?
Yes.
Do you have any questions about your constitutional rights?
No.
Any questions about anything we discussed today?
No.
You understand that if you plead guilty, you are waiving all of these important constitutional rights in this case?
Yes.
All right. Ma'am, knowing everything the court has discussed with you, do you still wish to enter a guilty plea as charged with count 1 of the indictment?
Yes.
All right. Counsel, is there anything further before I accept the plea?
No, Your
All right. Madam Prosecutor, may I hear a statement of facts?
Yes, Your Honor. Patricia Abrams, on or about June 25th of 2025, in Hamilton County, State of Ohio, knowingly obtained, possessed, or used a Schedule II controlled substance, to wit, fentanyl, in an amount less than 1 gram, in violation of Section 2925.41A. Your Honor, more specifically, officers stopped Ms. Abrams and found a white powdery substance on her person. The Hamilton County Crime Lab identified that substance to be fentanyl.
All right. Anything on those facts, counsel?
No, Judge.
Ms. Abrams, did you hear what the prosecutor said you did?
Yes.
Is it true?
Yes.
All right. What is your plea to count 1, possession of a fentanyl-related compound?
Guilty.
Let the record reflect that Ms. Patricia Abrams was present in court with her lawyer, Mr. Jeff Diamond, and that Ms. Abrams was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Abrams understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Ms. Patricia Abrams guilty as charged in count 1, possession of fentanyl-related compound, a felony of the 5th degree, in violation of revised code 2925.11 subsection A. Count 2 of the indictment is dismissed at the state's request. Counsel, is there any reason why Simpson should not be entered today?
No, Your
All right, are you waiving the PSI?
Honor. We would, yes,
All right, what would you like to say on behalf of Ms. Abrams?
Your Honor, obviously she's here today. Today, we said early on she was taking ownership of her, that she made a mistake. But we went down kind of what had led her down this path. She had been sober for about 5 years. She's doing very well. So obviously in my head, something had to trigger this. And she had told me February of this year, her husband died in a car accident. Fortunately, also in that car was her brother. She
Her
lost,
brother?
Yes. She lost 2 people that were extremely close to her. And she tried to manage that in a legal way, I would say, in a more healthy way. Ultimately, loss of both of those individuals that were very close to her led her back to using. She's clearly been clean since. Obviously, she's been in, I think, 3 days now. She's been in contact with the addiction services while she's been locked up. She plans to go to a living judge. But this was a trigger that obviously, we can't predict what's going to happen in the future. Something, God forbid, nothing happens like that. But she knows she needs to find a better, healthier way to cope with loss and things that come up, stressors in life. And so that's really focus, is trying to get help with that and also help with just processing the loss going forward. But again, Judge, she's been doing really well. I think this is something, obviously, she's not proud of. She knows she messed up, and she's hoping to move forward now. And even though, obviously, being locked up hasn't been ideal for her, at the same time, it gave her a long, rather, almost 4 months that she's been sober, and able to kind of go through what triggered the initial her using a judge. I was just supposed to take all that into consideration, and believe that she'll be an issue for the state of Ohio going forward. And she does certainly seem to be taking it serious. Like I said, when we first met, I could tell she was almost disappointed in herself, Judge, that she did all of it.
All right, thank you very much. State?
Your Honor, the state will just note, there's 3 prior possession charges that I can see in the out-of-county record, and with that, we'll refer before I leave.
All right, thank you very much. Ms. Abrams, is there anything you'd like to say before I pass sentence?
Just, I've been on the Suboxone now for almost 4 months, and I'm doing really well with it. And I'm going into really, whether I get sentenced to it or not, I pretty much lost everything again in here again. And just tired of living like this. So regardless of what happens today, you know, stand, do whatever I do to stand this path. And I know I need professional help to get through what happened. And I plan on seeking it as well.
I'm sorry for your loss. That's a pretty significant loss in your life. So you didn't seek any grief counseling?
No, I was in a Suboxone program, and I don't know, once I looked into, took a couple of online grief courses, but it was too much.
Yeah.
Too much of a check.
All right, I see the officers here. Is there an officer want to say anything? Okay, officer, would you like to say anything?
No, ma'am.
All right, thank you very much. All right, so your plan is to go to sober living?
Yes.
Where?
The rest home, I've been just talking about it to inmates in here, we're talking about sober living in general, and that's the one that I looked into, and I called them, and they're a place you can go in, they'll try to place you in a house the same day you go in, and if not, they've got a little, I don't know, detox holding area where you can stay for a couple of nights, because I will be homeless when I leave here. So that was the one that I chose because they could get me into one same day. I'll be somewhere tonight, say.
I see. And do you have any other family members, family support?
Yeah, they're not near here, they're in Brown County.
Oh, I see.
So it's not like, you're in the house quickly, because I've been staying in Harris County, but like, I don't call and stuff like that, if I need to call somebody for help, it's stressful, I guess they can come out and help me.
Right. Where's the sober living?
I don't know which house they would put me in, it's called Rest, and they are somewhere you go to and they find a house for you. That's how it's on Ferguson,
And it's called what?
Rest, R-E-S-T.
Oh, Rest. R-E-S-T on Ferguson.
You know, we'll make some shares, bus vouchers and everything from the better social services. Well, I'm sure you can get there.
Okay. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state and local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. No restitution in this case. I reasonably calculated this sentence to achieve the 2 overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Ms. Abrams, I hereby sentence you to 103 days in the Hamilton County Justice Center with credit for 103 days in the Hamilton County Justice Center. Costs and fines remit. I'm not going to put you on probation. I don't feel the need to do that.